Hey everyone, it's Professor Morris, and welcome to another lecture. This is the week 3 class lecture. And if you haven't already noticed, you certainly will hear it from me first, then in this recording. But in the announcements section, I posted a very important announcement that we are moving the midterm exam from this Thursday, which would be, I guess, May 30th, to a week from now, to Wednesday, or excuse me, Thursday, uh, June 6th. Um, and I always love it when Zoom puts its menu right in the way of what I'm trying to get to. There we go. Here it is. The class announcement on the midterm exam. Again, this is all my fault. I sincerely apologize if this change has created any type of confusion or inconvenience for any of you. That certainly was not my intention. And I'm also not one of these professors who's too proud to admit when he is messed up, because I certainly did. I did not factor in the holiday when I was counting up the weeks of the course and when a good time would be for the midterm exam. I also thought we would get a little more material covered than we had covered so far. And again, that's on me. But as I've said before in this course, my priority for you is teaching you this material. The tests I know are important, and grades are super important. I get that. I went to college too. I know how important grades are to you, and I certainly want everyone to do well in this course as a result of that. And so I'm moving the exam uh, out a week to June 6th. So instead of the exam this Thursday, the midterm exam this Thursday, we're going to move it to Thursday, June 6th. Now that only gives us 2 weeks before the final exam. But I think by that point, we're going to have enough of the basics under our belts to where we can kind of move a little bit faster with some of the real estate transaction stuff that I want to talk about in the second half of the course after the midterm exam on Thursday, June 6th. So again, midterm exam, not this Thursday, May 30th, but Thursday, June 6th. Same deal, 25 multiple choice questions. We're still worth 100 points, 4 points each question. And I still will be releasing a study guide probably in the next couple of days. I want to give you a chance to review the lecture I'm going to talk about in a minute first, and then start focusing on preparing for the exam. Again, another reason to move the test. So again, I apologize for any confusion or inconvenience, but I do believe that this is in your best interest. So with that said, let's talk about what we're going to talk about in week 3 of the course. Um, we have so far we've kind of just kind of driven home the concept of the fact that land and real property are special. They're unlike any other good or service that you can contract for or you can buy or sell or own. That you that there are very special rules that come with with owning real property, and there are different ways to own the real property based off of not just the fact that whatever land description is in the deed, whatever the legal description shows in the deed, which is the actual description of the property that you own or that you're buying, um, but also the type of title that you're going to assume. And whether or not it's a concurrent title with someone else, or whether it is something that you're just going to pay a mortgage on and pay off over time, especially if that property has a home on it. Um, and all of that has to be done with regards to certain formalities, and that's what we're going to kind of talk about today, which is a couple of things. First of all, are these sort of add-ons to various property deals when it comes to the use of the land, as well as problems that can arise if you aren't following all of the rules that we've talked about in the first 2 weeks of the course when it comes to property land descriptions and property lines, and knowing where those lines are because of a good survey, and being very careful before you build anything on your property, that you know exactly where those property lines are, so that you don't create a lawsuit for yourself that could cost you or the people that you care about lots and lots of money, not to mention a huge hassle. And it's also, let's face it, you're not being very neighborly if you build a fence between you and your neighbor, and you mess up and you build your fence on their property because you didn't know where the proper property line was, and the owner of the other property, the adjacent property, finds out and sues you, and then you've got to tear the fence down at your own expense, rebuild it on your side of the property line. And again, it can just add a huge amount of expense to what was already probably a pretty expensive project. And that includes any structure. It could be a fence, it could be a tool shed, it could be a garage, it could even be part of a home. God forbid, if you build a part of your home on someone else's property by mistake, and you have to tear part of that down, that's going to be really expensive and a major problem. So we'll talk about how that all works, and what to do in those types of situations when we talk about easements, licenses, and encroachments. The other thing that we're going to talk about today is we're going to kind of dip our toe into the proverbial pool of contract law. We're not going to talk about real estate contracts right off the bat. We're going to just, for this week, just touch on basic principles and concepts of contract law, offer, acceptance, consideration, um, and the fact that, and we're going to talk about something called the statute of frauds, which is super important when it comes to contracts for real property. And then we're going to again kind of go over some of the basic generalities when it comes to contracts, and why it's so important to follow those rules, because I mean, courts are full of legal cases between parties who are fighting over contracts that either one party didn't fulfill their end of the bargain, or there's a term that isn't clear in the contract, or there are other issues with enforceability that can come up, and we're going to discuss a lot of that today as well. But remember, we're going to wait and talk about real estate contracts, the purchase or the sale of real property, because there are special details that come with that. We're going to do that after the midterm exam in the week 4 class lecture. So the way it's going to work is we're going to do the week 3 class lecture this week. Again, a short week, obviously. And then on Monday of next week, I'll go ahead and post the week 4 class lecture, which will have a discussion about real estate contracts in it. But that will not be material that will be testable on the midterm. That's one of the other reasons why I wanted to move the midterm exam a week further in the calendar, was because I didn't want to give you new material that you're going to have to learn, at a shorter pace and at a faster pace than normal. I don't think that's fair to you. And also I wanted to give you, again, more time to just kind of mull over this stuff, and then ask questions if you have it, and have them, and anything else that I can help you with, so that you do your absolute best on the midterm exam. So again, we're moving the midterm, and that's one of the big reasons why we're doing it, is to give you enough time. So we will have a week 4 class lecture next week at our normal time on Monday of next week. But none of that new material in the week 4 class lecture will be testable on the midterm exam. Just again, wanted to kind of keep that clear. You'll probably hear me repeat it a couple of times in between now and the midterm exam. But again, I just wanted to make sure everybody was on the same page when it comes to that. With that said, let's talk quickly about the week 3 class lecture. I'm just going to kind of go over some of the main points and some things that I think may warrant some kind of further discussion. And again, try and answer your questions before you have to ask them in anticipation of things that sometimes give students problems when it comes to learning how some of these terms work. And I think the biggest thing when it comes to easements, encroachments, and what we learned last week, another word that starts with the letter E, encumbrances. Easements, encroachments, and encumbrances, they all they're all technical, legalese sounding, and they all start with E, and so it's easy to kind of get those confused. And so we're going to, again, spend a little more time talking about this and maybe give you some hints on how to remember what these terms mean and why. So first of all, let's talk about what an easement is. And an easement is basically it's a permanent right of way or permission for someone other than the property owner to either use the property or to have some type of way through uh, to get to their property if their property is locked off and has no road access to a main road. For example, and for those of you who may live out in the country or in more rural areas, you're probably more familiar with this. And that is that you normally have like a major highway that runs near your home, but not all of the property lots, but that highway. In other words, there are lots maybe behind another lot that's right next to the highway, and the only way they can get to the highway from where their lot is located is to cross your property line. And so in those types of situations, the owner of that property and the owner of the other property will kind of meet and kind of cut a deal. And it can be you know uh, for something of value. It can be like a contract, or it can just simply be an agreement between the property owners as good neighbors. And that is, well, if your property is situated behind mine and the only way you can get to the main highway is to come through my property, then I'm going to grant you an easement, which is again, it's just a written document that simply says that you have the right of way to pass through my property when you need to access the main road. Some properties share a common driveway as a result. Other properties, an easement can be for utilities that either run below the ground or above it, and you have to grant an easement to the utility companies in order to service those lines, in order to keep them going, especially if they go out. And of course, because you want to make sure that your home gets utilities and that those utilities aren't interrupted in any way, you have an interest to grant that easement to the city or the county or whoever the utility provider is in your area where that property is located. And so those are the most common types of easements, and that is usually what we're talking about when we talk about an easement is some sort of right of way that allows somebody to kind of traverse either across your property line or through it, and not be in violation of any type of trespass. You'll see in the written lecture that I talk about trespass again this week. And trespass is just simply it's a tort. It's a civil liability that you can sue somebody over, sort of like a personal injury is a tort. It's a civil action. It's not criminal in nature, even though there is such a thing as criminal trespass. But that's not something for this course. Actually, we may get to it later on in the course when we start getting into the weeds a little bit more with regards to property rights. But as far as the purposes of today's lecture,
when I talk about trespass, I'm really talking about just civil trespass. It can be intentional or unintentional. But if you build on someone's property by mistake, or if you intentionally build on it, even though you know where the property line is, but you do it anyway because you think you can get away with it, it doesn't matter. If you're on their property, if you're on someone else's property line and you've crossed it, then that is an actionable offense. And if the other person, that property owner, finds out about it, they can take you to court. And if they can prove their case under oath, then that judge is going to order you to tear down whatever it is you built or created that caused that trespass, and that can be a real problem. And another fancy word for trespass that you'll see in today's written lecture, in the week 3 written lecture, is this term called encroachment. And when you hear the term encroachment, I want you to think of trespass, because encroachments and trespasses are sort of the same thing. Encroachment is simply the sort of the noun that describes the trespass. So if someone is engaging in a trespass, a verb, the thing that is causing that trespass would be the encroachment. And encroachment, as you can see here up on the screen, is anything is excuse me is the use of someone else's land without getting their proper permission. So, in other words, the opposite of an easement. And sort of a clever way, I don't know if it's very clever or not, to remember the difference between easement, encroachment, and encumbrance. Is an easement, when you think of easement, it's easy. If you need to easily get from your property to the main highway, using the example I just used before, then you're going to use an easement to do that. You're going to need that granting from the landowner to give you permission to traverse across their property, and that protects you from any claims of trespass by that property owner. Uh, Whereas an encroachment, and if any of you folks like football, if you're big football fans like I am, then you're going to want to sort of associate the term encroachment, which is when one of the defenders lines up in the neutral zone and is offsides. That can be deemed, some referees refer to that as encroachment. And again, that is when you've got somebody crossing the line illegally in a football game. It's the same thing in property law. It's the same meaning. In fact, it is somebody crossing a property line without permission by the property owner on the other side. And in doing so, you are basically engaging in trespass at that point. And those encroachments need to be cured because and as we get to uh, adverse possession later on in the course, you'll understand why curing encroachments is really important. And by the way, the term cure is another term of art that I throw out in this written lecture. And when you cure a problem, that is usually either a problem that is a violation of a contract, or it could be some sort of curative action when it comes to fixing an encroachment. Um, and it could be anything that a party does to fix a problem that they could otherwise get sued for. And you hear the term cure often in contract law and in real estate, where it's basically you're fixing the problem. And again, that you can certainly understand the meaning there. To cure something, to fix it, to cure an illness is to fix that person's health and to help them regain their health as they were before. Uh, Curing a trespass issue or an encroachment is simply fixing that problem so that it no longer is a legal liability potentially to you or to someone else. So keep that in mind as well. Um, and you'll you see me kind of throw out the idea that if you're going to build something and you think it's anywhere even remotely close to the property line of the adjacent property, you probably want to get a survey done. This is where you call those folks that we talked about last week with the transits and the measuring sticks, and they measure the degrees or the meets and bounds of your property to find out and assess exactly where those lines are. In fact, from time to time, especially in a newly developed area, you will see you'll be walking around and you'll see like spray paint on the grass. And you're like, what the heck is this? Well, that is usually from a surveyor who has marked that as a place where there's either maybe a potential property line, or it could be a utility marker where there's an underground power line. And the reason that's important is because there are various requirements under Florida law that people who want to develop their property or build on it in any way or dig in any way underneath the ground, there are certain rules that you have to follow, and I kind of go into that a bit in the written lecture as well. So getting a survey is important, and also again notifying the proper authorities, especially if you're going to dig anywhere, because now, especially with the number of hurricanes Florida is getting these days, more and more utilities, especially in newer developed areas, are burying power lines as opposed to putting them up on poles where they can be knocked down by trees and wind. And so you really do not want to create a problem for yourself or for your neighborhood by digging without getting proper permission from the city or this county or wherever it is where you're wanting to dig, wherever your property is located, and whatever governmental entity and municipality has jurisdiction over that area. Because if you hit a power line, not only could you hurt or kill yourself and other people around you, but you could also take out the power for an entire uh, block, if not even an entire grid of the city or county where you live. So there is a state statute that I refer to in this week's lecture that requires you to call 811, which is the number for the state hotline for folks who want to develop their property and dig. So again, you want to make sure that you do a survey so you know exactly where those property lines are. And you also want to make sure that if you're going to dig, that you call the state and you notify the state first so they can come out and mark those where those potential utility lines, sewage lines, and anything else that could get in your way if you did decide to dig could be a problem. And if you don't do that, if you don't make that phone call and give them time, I think you have to give 48 hours notice, and you end up damaging something important or expensive, you could be liable for that. So again, it's super important that if you're advising a client who is buying a new property and they're like, oh, I can't wait to build my new house, you want to kind of make sure that you go over that you or your attorney supervisor go over with the client in specifics that statute that requires them to notify the city or the county wherever they live. Some areas of a city are run by the city. Other areas they can be within the city limits, but the county has jurisdiction. It's just kind of weird how city and county municipalities work, and it's kind of sometimes different for different parts of the state. But the bottom line is that you want to make sure that you protect yourself, and if you're the paralegal working at a real estate firm advising a client, you obviously have a duty to your client to make sure that they're well informed with regards to what the laws are before they develop. And so getting a survey done is always smart. It's not expensive, and it certainly can avoid major issues. And then, of course, again, notifying the city or county by dialing that 811 hotline before you dig. Which leads me to a quick sidebar that I kind of put these uh, little info factoid areas in my discussions where I don't know really where else to put them. I just refer to it as a sidebar. as some of you already know, if you've taken civil procedure, a sidebar is simply where the attorneys and the judge kind of converse during a trial. And it's outside of the earshot of the jury. Usually the jury is excused at that point while they hold the sidebar, and it's usually to discuss and go over procedural issues in the case and in the trial. Well, I refer to these as sidebars just to kind of be cute, I guess. And this is where I talk about the fact that when you own property, when you own land, that you own everything above it as well as the land itself and below it. Um, the air the airspace or airspace rights do only go up 500 feet. Anything beyond 500 feet is jurisdiction of the Federal Aviation Administration, or the FAA. They're the folks who do all the air traffic control stuff, and they regulate all air traffic in the United States. It's a federal agency, obviously, and so state law doesn't apply there. And I sometimes get a question from students of, well, if I wanted to build I don't know, an observation tower that was 499 feet, could I do that? And the answer is, if you built it properly and you got a permit for it, uh, which probably wouldn't be easy to do, and it had all the lights and everything on it that were necessary for radio towers and other really tall objects like tall buildings, to let aircraft know that this thing is there, especially at night. Um, you could do that, but you'd still have to get permits from the city and the county and potentially even the state. But anything over 500 feet or 500 feet or above is the pure jurisdiction of the FAA. So you do own the airspace above your property, but only to a certain point. Below it, however, is a different story. Other than that requirement, and here's where I talk about the requirement. It's called the Florida Underground Facility Damage Prevention and Safety Act, or Chapter 556 of Florida statutes. Uh, and it requires, again, that you contact that 811 hotline before you dig. In fact, you have to give the city or the county, whoever, again, has jurisdiction over your property, at least 48 hours to come out and mark where the utility lines are, any power lines, anything that could potentially create some sort of harm or potential damage to infrastructure uh, by again marking those areas properly. And if you fail to do that and you dig and damage something, you can be liable for it. And some of that stuff's really expensive. And of course, if you cause a power outage, that can also be a problem. And you can also obviously severely injure or kill yourself if you hit a power line and you were using, something metal that conducts electricity, and get not only electrocute yourself but probably everyone around you. So it is really important for safety reasons, for infrastructure reasons. But the cool thing is those subterranean rights, and that's the formal legal term of art used to describe the ownership rights of everything underground, below the ground. That is anything you find down there. Obviously, buried treasure, great, but usually it's some type of mineral, uh, some even in Florida, people do find oil from time to time. Not a lot of it, not enough to make you wealthy, but if you own property in certain parts of the country where there is a lot of oil in the ground, like the Southwest, like Texas, or certain parts of Colorado, then absolutely. Obviously Colorado, there are a lot of silver veins and even veins of gold in certain areas, and you get lucky and you strike gold, that's yours. That doesn't belong to anybody else if it's within your property line. Now, when it comes to mineral rights, because minerals usually kind of are dispersed in veins. In other words, they kind of go all over the place. It's quite common for a vein to go right across people's property lines, and then there's a big fight over access and who owns what, and that can all be litigated later on in court. But the point for today's lecture is simply that when it comes to subterranean rights, you own everything, but you got to make sure that you notify the state first before by calling that number before you dig to give them a chance to send folks out to give you proper guidance so that you can avoid not only major issues for lawsuits and damage, but obviously personal safety. So let's quickly talk about licenses. We've talked about easements. We've talked about encroachments. Encroachments are just simply unlicensed structures on people's property. Uh, and let's talk about a license. And a license is kind of in between an easement and an encroachment. In other words, an easement is permanent. Um, Once an easement is created, unless it is invalidated by both parties who originally agreed to the easement, that easement will do what they call run with the land. In other words, that easement will then become part of the deed as an attachment or an exhibit to the deed. And when that property is sold, that easement goes with it. So again, if you are the owner of the property that's right next to the main highway, and the the person next to you is the person who needs that easement to cross your property to get to the highway because they're kind of landlocked behind you, which again is very common. Um, if you are the new buyer of the property that has the easement, in other words, the your neighbors, the people who need to get across your property to get to the highway, when you buy that land, when you get that deed and you get a chance to look at it, you're going to see that easement there. Your attorney, or if you're the attorney working or the paralegal working on the case with your supervising attorney, you'll find that when you do the title search, and you'll see, okay, it's got an easement and grants the neighbor the right to traverse the property. Now, the reason that's important is because there are some folks who, especially if they're buying property in a secluded area or in an area that, let's say, it's near a body of water or it's waterfront property, uh, and they're buying it to kind of have a sense of isolation, and they're very private, and they really don't want people driving their vehicles on your land, even though it's probably only for a few seconds while they get to the main highway or to the beach or wherever it is where they're trying to go. Uh, Knowing about that easement may be a deal breaker for buying or selling the property. Um, Depending on the type of easement it is, because it runs with the land and because you as the new buyer do not have the authority to void that easement on your own. You need permission from the other person who benefits from the easement in order to invalidate that easement. You can't do it by yourself, even though you're the new property owner. Uh, because you know about it ahead of time before you actually sign on the dotted line on that contract to purchase the property, uh, you have the right to walk away. You may say, I don't want it. I liked the property before, but now that I know about this easement, I'm not real thrilled about it. That happens all the time. That is very common. And it is one of the reasons why doing a good title search where you make sure that whoever that buyer is knows what they're buying and that they could be buying a piece of land that grants not only the next door neighbor an easement, but maybe everybody in the whole neighborhood is a party to the easement, which is even more people that you would have to go to get that easement invalidated. And so chances are pretty good that easement's going to stay, and that may be a determinative factor into whether or not you go forward with the sale. that you go forward with the purchase of the land. And if you're the paralegal or the attorney, your client may back out at that point and go, you know what? I love the property, I love the location, but I don't like people on my land and I don't like this easement. And since I can't get rid of it on my own, and all the other people who are benefiting from it don't want to get rid of it, then the only choice I have as the potential buyer is to walk away from the deal. And that is very common. So again, easements, think again, ease of use, or being able to easily cross someone's property without being in violation of trespass. Easements are permanent. They run with the land. And again, unless they are invalidated by both the property owner and the party who benefits from the easement, that easement's staying. And again, it is part of the deed. You'll see it in the title search. In fact, there will usually be a number of potential easements with regards to property, with regards to utilities or other matters. And it'll be up to that potential buyer to look at those and talk with the attorney and maybe with you, the paralegal, to find out if this is something that they really need to be concerned about, based upon what the language says. And usually you can pretty easily determine what the easement grants and doesn't grant, from the language of the easement. So again, easement, much more permanent. Encroachment, that is akin to, again, a penalty in football. You're crossing someone's property line without their permission, and you are trespassing. You are in violation of civil law, and you are could be civilly liable if you've built something that encroaches on someone else's property. And so again, easement, encroachment, encumbrance, we talked about last week, and that is just any attachment or lien or debt associated with a piece of property, that has to be resolved before that property can be sold, before free and clear title can be granted so that the property can be sold. And again, that is a different E word that we talked about last week. Licenses are kind of in between encroachment and easement. In other words, they're not permanent, but they do involve permission. And a license is just simply, granting somebody permission to do something, but it's usually something special, something very particular on your land, that you only usually grant to one person or maybe a small group of people. It's not, an open invitation to the world. And it usually involves, the best example I remember from law school is somebody getting permission to uh, fish on someone's property at their lake. And it was a case involving someone who grew up near that lake as a child. They grew up in a home several lots down, but they would always go over there as a kid and fish before anybody owned that property. It was, the kid wasn't really trespassing, but and just grew up fishing there. And as they grew up into adulthood, they wanted to continue to fish there. And when they found out the property was sold, they would go up to that property owner and say, "Hey, I'm Ben Morris, and I grew up here, and I grew up fishing here, and I just want to keep fishing. It's just me. I may take a couple of bass here or there. That's about it. And I usually throw them back anyway. Is that okay with you?" And if it is, then the licensor, that's the person who owns the property, would fill out a written document. It's got to be in writing. We'll talk about the statute of frauds in a minute. And then you would have a license to fish. But here's the deal. That's all you have a license to do. If you, and the example I use in the written lecture is, let's say that same person decides that instead of me just going over there and fishing, it's going to be me and a couple of buddies with me too. Well, if those buddies aren't included in the license, the written document that says that you have a permission to fish there, then technically, again, technically, you're in violation of the license. Now, is a landowner going to call the police and accuse you of trespassing, criminal trespass on their land? Probably not. Are they going to sue you civilly for civil trespass? Probably not. Are they maybe going to yell at you later and say, "Hey, I only said you could fish there, not you and your buddies." And the reason is because all all documents that pertain to land, any agreements that pertain to land have to be in writing according to the statute of frauds, which we'll talk about in a second. That's number one. Number two is if you're the landowner and you've let this one person on your land to fish at your lake, as again, just out of the kindness of your heart, you didn't have to do that, but you decided to, uh, and now they're bringing buddies over there. Well, before you know it, the person you granted the license to may not come one day, but the buddies will. You don't know those people from Adam, and they may not be people that you want on your land. And since you didn't cut the deal for fishing with them, uh, that may be a real issue. And so again, it's important that if you are the licensor, you're the person granting the license, that you enforce it, that you make sure that you protect your property rights by enforcing that license if you decide to grant it. And by the way, as the licensor, you can cancel that license at any time. Unlike an easement where you need both parties to agree to canceling the easement, when it comes to licenses, nope, easy peasy. All it takes is the licensor, that's the person who owns the land, to say, I don't like this deal anymore. I'm canceling your license. You can't fish here anymore. Now, if you're the licensee, you're the person who's not the landowner, who's being given that special permission to use that land for a very specific purpose. Your job is to make sure that you follow that license, you follow the terms of the license so that you don't lose it. Because it's up to the licensor to allow you to continue coming onto their property. And if you mess it up by bringing other people along, or by the other example I use is, instead of coming onto the land to go fishing, which is what the license says, you decide you're going to go dove hunting or quail hunting or whatever, uh, then obviously that's a problem, because that's not what the license says. And even though, again, is the licensor going to have a problem with that? I don't know. But do you want to take that chance and potentially lose your right to fish there without having to, make amends? Uh, you really probably don't want to mess that deal up. So if, again, you're the paralegal advising the landowner and it's a license deal, you can tell the landowner, hey, you can revoke this at any time, and you need to enforce it. If you are going to grant this person a right to come onto your property, then you need to make sure that they only come onto the property for certain purposes that are articulated within the terms of the license. Whereas and if they don't follow your rules, then you can revoke that license at any time. Now, if you're advising the licensee, the person who's being granted the special permission, then obviously you want to tell them, hey, don't mess this up. Okay. This person, out of the kindness of their heart, is allowing you to come onto their land and fish. That's great, but don't don't do something dumb and bring a bunch of other people there that aren't allowed, or try and change up the deal by going hunting instead of fishing, because that person could yank your license, and then you don't have any right to be there at all. And if you go back out there again, then you are in violation of trespass. And yes, there is criminal trespass, which is that's intentionally trespassing when you know you're not supposed to be on someone's land, and they posted signs that say, hey, private property, don't come here, you're not allowed. uh then and you either climb a fence, or you disregard the signs, or that that's not your property but you're going to go there anyway, then that can be considered a criminal offense. In most states, including Florida, it's a misdemeanor. However, if you are trespassing with the intent to commit a crime of some type, then it can be bumped up to a felony. So trespass is a big deal, but again, most of the time, 9 times out of 10, it's a civil matter, and people are usually suing each other over trespass due to some type of encroachment, where again, someone has built something improperly because they didn't get a survey done and they didn't know where the property line was. So again, understand how licenses work, that they're very temporary. They're not permanent. They don't run with the land. They can be canceled at any time by the licensor, and they are usually for a very specific purpose. And it's usually again a neighbor wanting to be kind to someone who wants to use their land for something special. And as long as the landowner is okay with it, they can grant that license. But again, it's got to be in writing, and it can be canceled at any time. Okay, real quick, because we're coming up on this getting long, and I don't want to go too long on this because we are going to spend more time on real estate contracts next week. But I want to make sure that you understand the fundamental basic principles of a contract: offer, acceptance, consideration. Offer, acceptance, consideration. Burn those three terms into your brains. Okay. Offer, acceptance, consideration, because those are the three musts that you must have. But I'm going to add a fourth thing, and that is with regards to real estate. Go ahead and get this. You can add this to the stuff that's rolling around in your head, and that is it's got to be in writing. All real estate transactions, whether it's a lease, whether it's a sale, whether it's a license, whether it's an easement, whether it's anything to do with real property, and it is some sort of contract, it has got to be in writing. It cannot be oral. Contracts can be oral. Uh, Two people can agree verbally amongst one another to do certain things, but due to what is known as the statute of frauds, uh, they can only be for certain things that are usually below $500, do not involve land or real estate, uh, are things that can be done quickly. In other words, anything that's going to take more than a year to fulfill as far as the contract goes has to be in writing. Uh, and again, um, it is hard and fast law in Florida due to, again, what is known as the statute of frauds, that any land agreement, any lease, sale, easement, license, any other any other document or any other agreement that involves land has to be in writing. Okay, so just go ahead and put in your head that yes, there is such a thing as a verbal or oral contract. They're enforced all the time. They're much harder to prove. That's why all land deals have to be in writing, is because the buying and selling or even leasing of land, or even just licensing to give somebody permission to go onto someone's land. These are usually things of value. And you don't want to be messing around with having to prove uh, who said what and when all you've got is a verbal agreement uh, when it comes to real estate. So with regards to the statute of frauds in Florida and in just about every other state in the country, uh, all land deals have to be in writing, and that includes any agreement that even involves real property. It doesn't even have to be the buying and selling. It can be a rental agreement. It can be a deal with a contractor to build something. Um, it's got to be in writing. If it involves real property, just go ahead and bake this into your brains that it's got to be in writing. Uh, so again, offer, acceptance, consideration. Consideration is just that exchange of something of value between the parties that kind of symbolizes that intent to bargain, that intent to deal, that intent to hold each other accountable. Um, and so you can agree, you can do an offer and acceptance in what they call a contract in principle, but without that consideration, you don't have a valid contract. You still have to have all three parts. So offer, acceptance, consideration. Um, Again, I'll let you check out the videos on consideration, what that means. I also, when it comes to any contract, really, uh, you have to have the ability to engage in a contract. In other words, you have to be of sound mind. You you can't have been deemed legally incompetent by a court of law. Uh, you have to be an adult. In other words, over the age of 18. Some courts will give minors permission to contract, but only in very limited circumstances. This is usually, like child movie stars and other young, minors who are engaging in contracts for lots and lots of money. Uh, they will sometimes allow the young people to sign those, or they'll, make sure that the parent signs. But the bottom line is that you have to be eligible to engage in a contract for there to be a valid contract. And one other thing too is the contract has to be possible. In other words, you can't have what's called impossibility with regards to a contract. Uh, and the best example of that is, a contract for the purchase of a car. And, there's an offer. You're going to sell the car for $5,000. Acceptance, the person accepts and says, yes, I'll do it. They even exchanged the money, but when the time comes to exchange the deed, you realize the car's been stolen and it's nowhere to be found. You obviously cannot enforce that contract. You can't, you don't have an enforceable contract there because you don't have a car anymore. Same thing as if the car were destroyed in a storm or something else horrible happened to it. If obviously the corpus or the whatever the thing is that's being bargained for is no longer in existence, then you don't have a valid enforceable contract. Um, uh, One other thing too is it's got to be something that is enforceable at law. In other words, you cannot have a valid contract for drugs, for illegal drugs, that is. Um, Anything illegal, obviously, if I'm want to hire somebody to hurt someone else physically or even to threaten them, that's obviously a crime. I can't, you know, if the person rips me off and takes my money, I can't go to the police and say, or to a court of law and say, hey, this person, I wanted him to go, scare my ex-wife, and threaten to kill her, so that she would, you know, I don't know, give me a break on my alimony payments. I don't have an ex-wife, but you know what I mean. And so, it would be a situation where not only would the cops want to arrest me. But a judge in that situation would say, Mr. Morris, you're an idiot. You're a bad person, and we're going to call the police now. And also, by the way, I'm going to dismiss your case because you cannot enforce an illegal contract. So it's got to obviously be something that is lawful. Um, and and again, I talk about the statute of frauds here. Uh, you can read that stuff on your own. If you have any questions about anything I've covered in this week's lecture, please let me know. And again, we've moved the midterm to next week, to give you guys a break and to give you more of a chance to uh, spend more time with this material. I really want you to do well on this midterm. I want you to learn this stuff. And obviously, it's my fault for not gauging the holidays properly, and the days of the week, and again, giving you enough time to do everything you need to do. So June 6th is the new midterm date. If you have any questions about that or anything else, please let me know. Hope everybody has a great day, and I will talk to you again soon. Take care.